Hello, my name is Faith Nuri. I'm certified family law specialist in the state of California. Today I would like to speak with you on part one of what you need to know when you're ready to separate from or divorce from your sponsored immigrant, partner, or spouse. For ease of reference, when I refer to a spouse, it also means your domestic partner. In general, when you're sponsoring a person to come into the U.S., you need to sign an affidavit of support, which is a federal form available on uscis.gov. It's Form I-864, where you um, basically sign this form promising to accept legal responsibility for financially supporting the sponsored immigrants in the U.S. As a general rule, the affidavit obligates you to financially support this individual, your spouse, or your domestic partner, until he or she becomes a U.S. citizen or can be credited with 40 quarters of work, die, or they're no longer a permanent resident and residing in U.S. It is crucial to note that if you marry a person you sponsored, your sponsorship obligation does not end if you legally separate from or divorce your sponsored spouse. This means that you're still responsible financially, even though you may be divorced. So if you sponsor the spouse, receives any means tested public benefits such as food stamp, supplemental security income, SSI, Medicaid, temporary assistance for needy families, then you as a sponsor must repay that to these agencies, those agencies that provided them to your sponsored immigrant. And if you do not repay the cost of those benefits, the agency can sue you and collect. If you ask your family or friends to co-sponsor, meaning that they also sign an affidavit of support because you were not financially able to meet the financial requirements, then that financial obligation also includes your co-sponsor. And again, they also are required to financially support this individual for 10 years or until they work for 40 quarters of work or they're no longer a resident. And it does not end, this obligation does not end if you legally separate from or divorce your sponsored spouse. The affidavit of support that you and perhaps your friend or family signs is considered by court a legally enforceable contract. This means that not only can the government come after you, the sponsored U.S. citizen, but also the spouse who you brought into this country could do the same. We had a recent case at Ninth Circuit. Ninth Circuit is a federal court that covers the federal courts in a specific jurisdiction or districts, and that's the District of Alaska, Arizona, Central, Eastern, Northern, and Southern California, and District of Hawaii, and it enforces the sponsored immigrants. Request to enforce the affidavit of support, and we had one case in matter of Erler versus Erler, which is a Ninth Circuit case that was published on June 8, 2016. In that case, which I'm going to go over it was a Ninth Circuit for our jurisdiction, and a subsequent case in marriage of Kumar. But this case was a California state Court of Appeal that followed the Ninth Circuit case and held that California family law state courts can enforce the affidavit of support, and the intended sponsored immigrant or the immigrant in this country is not required to go to federal court and seek enforcement. They can go to the family court and obtain the support that they require based on the affidavit of support that was signed by a sponsored in this case. So the fact that our family courts are at the state level now enforcing affidavit of support against the sponsoring spouses is very important, because many U.S. citizen spouses turn to prenuptial agreement or premarital agreement in order to make it very clear that neither of the parties are entitled to receive a spousal support. But for example, in the case I mentioned earlier, there was a premarital agreement, and in that case, court considered that the affidavit of support that was duly signed trumps over the premarital agreement. So whether a premarital agreement can still be enforced in light of affidavit of support, I believe there are options, but we will discuss that another time. At this time, I'm just going to discuss the issue of affidavit of support and obligation of the sponsor in this case. It's also extremely important to note that because the U.S. citizen spouse seeks spousal support or alimony, the family court usually requires the spouse to show that they have need and that they're going to be at some point self-sufficient. There are specific family code for that, but with affidavit of support, there is really no obligation to seek and find employment, and whether the sponsored immigrant is working or earning money will only come into effect when the court considers the amount of support payable. So I give a word of warning to unwary. Do not agree to sponsor or co-sponsor anyone unless you understand and agree that you're accepting the full legal obligation to support the immigrant, and that obligation could last up to 10 years or 40 quarters of work for the sponsored immigrants, or until the immigrant is no longer a green card holder or immigrant card holder. In my law practice, I handle both family law and immigration law cases, and I have done so many of them for over 16 years. Often I have cases where, and I see my colleague cases too, where one party to a marriage comes to the U.S. from an underprivileged country or country that they had the family didn't have financial means. So the affidavit of support now protects these kind of immigrants coming into this country because they can't just be kicked out on the street. And the prenuptial agreement that is usually customary by many families to have the intended immigrant to sign, it's no longer enforceable in light of affidavit of support based on a Ninth Circuit case. But again, there are exceptions I think that we will discuss another time, or exceptions that I think that could be implemented and put into effect. But that said, the immigrant spouses who are coming into this country, usually they have not much assets, and they're coming here and they are counting on the U.S. citizen to support them and sponsor them and assist them. I now see that sponsored immigrants, in light of new court case law from the calls I get, that they're trying to using the affidavit of support as a bargaining chip with their U.S. citizen spouses, where there is a marital discord, because the sponsored spouse, before filing, for divorce, they may try to negotiate that, just assist me to get my permanent residency, and then, I will not seek support. We will explore later on at another session whether these agreements are even worth the paper that they're written on, and whether this is a legal and enforceable contract. I get a lot of calls from sponsored immigrants as well as U.S. citizens that they're trying to find a solution or an easy way to get out of their marriage and avoid having to either pay support or forfeit their green card. I believe I will continue to get these calls, and because the reality is that many of these marriages are entered into without much investigations. In many cultures, elders pick the partner, and the marriages are arranged, not forced per se, but it was arranged, and it still happens every day. Many couples have nothing in common except their families, their interests, and their nationality. When an immigrant spouse is brought over to U.S., they may not be able to adjust to, the lifestyle here. They may not have a lot in common, and it may take a long time for them to adjust, and they may not be able to adjust as quickly as expected by the U.S. citizen, and they may lag behind culturally, knowledge, and emotionally. So imagine someone sending you to, let's say, Afghanistan, and you are to act like an Afghani and speak the language and be able to assimilate that. The culture and assimilate into the society. Think another example of a Cambodian national brought over into U.S. and asked to learn and speak English quickly and act like an American and get a job. Your perception of what an American should act like or could be completely different from your immigrant spouse's perception. And many people do not ask their immigrant spouse about their vision of what life will be like in America, and they really don't communicate as what is their perception and what is their expectations. So there are some disappointments because of not really navigating and inquiring from each other better. Sometimes due to control issues, lack of communication, power struggles, an immigrant spouse is kept away from learning English and is sometimes isolated. This puts a strain on marriage, obviously, and I could tell you that many ways that marriages under these circumstances could go wrong. We could talk about it another session. If you're considering a legal separation or divorce from your immigrant spouse, consider meeting with an attorney. and try to mediate your dissolution by being fair to one another. We all have our own perceptions. Both parties need to try to look at things from their spouse point of view, to reach out to each other and hopefully understand each other better. There is always a solution if you're open to listen and understand best you could what other party's perception is. When you meet with your attorney, you should come away understanding what solution serves you, or better yet, what solution serves your family. Taking a global look at all the issues that you have and try to find a solution for you. I hope this assisted you and give you insight into some of the issues that you may face if you are interested or to sponsor someone, or you have a sponsored an immigrant, in particular a spouse, and you're ready to separate from or divorce your spouse. It's a global view of those issues, and I hope will assist you as you proceed with this chapter of your life. Thank you, and have a beautiful day.